Welcome to the MedTech Wealth Advisor Podcast with your host, Matt Nelson. Matt, good to be with you. How are you today?
Doing fantastic. Looking forward to the topic we have on the docket today.
Well, the topic you have on the table today is a really necessary topic and one that I have to admit I'm a bit guilty of not following at the moment. So I'll be hanging on to every word
Yes,
that you talk about today.
we can run out and finish it up. Yes, yeah, we're going to talk about the basics of what you need to think about with your estate plan. And so today I have with me Jennifer Santini. She's going to join us and shed a little bit of light. I hope we'll have a good dialogue about it. Jennifer is with Sakura and Satini. And she just a little bit of background on her. She um, went to Colby College as a BA in government, got her JD from New England School of Law, been practicing with her business partner, Jane, now since 2009, I believe. Is that right, Jennifer?
Yep.
Yes.
Yep.
And not just that, but she's actually pretty involved in the estate planning community. She serves as the head of probate and the trusts section for the Minnesota State Bar Association. Basically, her and Jane teach this stuff to other attorneys. So I think
So you have an expert. You have an
yeah, I
expert
think
with
I
you, right?
do. I think I got a good one.
Good.
Yes.
Excellent.
And so what we're going to talk about and why I even brought this up is, back on episode 5, I brought up sort of the 3 phases that I think of that people need to plan for. I mean, basically you're alive and well, you're alive and not well, and then you're not alive. You're dead. You're gone. And you really just have to kind of boil it down to the 3 basic realities of what we need to plan for. And so today we're going to talk about some of it that's maybe not as comfortable. What happens when you're alive and not well, or maybe gone. And so, Jennifer, thank you for joining us on the show.
Of course. Thanks for having me.
Yes. So we are going to go into, I figure on this episode, we'll kind of stick to the basics because there's so much to cover. We'll probably have to do a follow-up episode on the advanced part, but we'll look at, what just is estate planning in general. Maybe you could go through the core building
Sure.
blocks of a plan. And then, how about what happens when there's not something in place? So those are kind of the 3 areas I want to go into. And, is there anything else you would add, or how you would initially start talking to people about it?
No, Matt, I think that that's exactly spot on. When I do sit down with clients for the first time, it really is trying to arm them and educate them. I think that there's a lot of misconceptions about what happens when people are incapacitated and certainly when they pass away. So it's really trying to clear that up. I do think it's also important for people to understand that while most of the states have somewhat of a similar process and similar laws, every state has some little quirkiness to them. And so it is really important that, if you haven't gotten this in place, that you do reach out to somebody who is licensed in your state to make sure that you are addressing things that are unique to your situation as well as the laws in your state.
Yeah, very good. And actually, before the show, we were just chatting about, some of the basics even to estate planning. And one question that'll come up once in a while is, well, can I just write my own will? Like, why
Right.
can I just like put it on a piece of paper? Is that good enough? Get my friend to
And
sign it?
Right. And we call those holographic wills. But the biggest issue, particularly here in Minnesota, is you need 2 witnesses. And so under the law, that is the requirement to have a valid will. So a lot of times people will come in and they'll say, my mom passed away, here's her will, and all it has is a notary. Well, then technically that's not a valid will. And so it's really understanding what are the signing formalities of these documents as well.
Sure, sure. Well, as we jump into kind of what a typical plan includes, I think about what the practical pieces of when I'm working with clients on the financial planning side of things. So, we're usually talking about their retirement planning and the
Mhm.
future and what, all the good things that happen. And then
Yeah.
the conversation at some point needs to turn to, okay, so if things aren't going as planned, we need to have this in place. So what needs to be in probably the most basic of a will, and I'm sorry, not a will, but an estate planning
Sure.
kind of setup?
Sure. And it is funny because a lot of times people will say, well, I don't need an estate plan because I don't have an estate. And it's, well,
Right.
and you always say, and I think the common misconception is an estate plan is for people that have millions and millions and millions of dollars. And it really, to your point, is to say, everybody has an estate, and it's also really trying to make sure we're addressing the times when you might be incapacitated or incompetent. So we try to educate people, both of our clients for themselves, but then certainly when they have adult children, that once somebody is over 18 years old, they should have a healthcare directive and they should have a power of attorney.
Hmm.
In some states, that healthcare directive, you'll hear it referred to as sort of a medical proxy, an advance directive. The old term, I think a lot of people would refer to as a living will. But it is the document that says you are living, but you cannot make medical decisions for yourself. Who would you want to be your voice? Who would you want to be able to make those decisions, or again, just sort of express what your wishes or convey your wishes about what you might want with your medical care?
Sure. Now,
And
if you're married, is that just typically going to be your spouse?
And that is, I think, a common misconception. So particularly here in Minnesota, the default isn't to a spouse. So again,
Hmm.
oftentimes I'll have clients come in and they might be a young couple and their parents are still living. And I always say, if one spouse is in the hospital and their parents show up while the other spouse is trying to make decisions, you can see where that conflict can arise.
Absolutely.
And the doctors are really going to look to the family and they're going to say, if we don't have somebody nominated or appointed by, the person who is incapacitated, and you guys cannot get an agreement, you're going to have to go to court and become appointed what we call as their guardian of their person, of their being. So by having that document in place, you get to be proactive to say, this is who I want to be that person.
That's probably comes as a shock to a lot of people
I
listening
think
to
it
this.
does. And only once in a while do I have spouses that sit in my office and I say this and they'll say, oh, I know, he went to go have surgery and man, they wouldn't share anything with me. And I say,
Sure.
well, it's because you didn't sign this document. I do think that a lot of the hospitals are trying, particularly if you are going in for a scheduled procedure, that they'll note who they have the authority to talk to. But it is really helpful if you go in and you say, this is who I've appointed and here's my signed document, the decision
Right.
made.
Man, that is really important to understand. I mean, that seems like that would be one of the first things you'd want to put in place.
100%, because you also think about it, it's you've got a scheduled surgery is a different scenario. It's the medical emergency. It's the time is of the essence decisions that possibly have been made. And we want to make sure that people are aware who should the doctors or the medical professionals call to decide, do they get surgery? Do we rush them to do X, Y, or Z, particularly when you're starting to deal with elderly clients? Do
Mhm.
they want to be resuscitated or not? And so I think another component of that document that's very important is also conveying, what are your wishes? What would you want in certain circumstances? What are your beliefs? What are your fears about what could happen in these, traumatic situations? And making sure that the people you name are people you trust to follow through with what those wishes are, and not allowing their emotion or their grief to take over, and again, or sort of reverse what you may or may not want to have happen.
Right. Now, is this going to be the same person that's making decisions financially for you, or how does that work?
I think that that also varies based on the people you are thinking about naming. I always say you want to name the right people in place. So if you are in a position where you have older children, I always say don't name the oldest of your children just because they're the oldest. Again, you want to name the people that maybe share the same values about your beliefs in your medical care for sure. Again, I'm starting to see with some clients, particularly elderly couples, they're fully recognizing they're not going to be able to make these decisions for one another. I mean, the clients that I have that have been married for longer than I've been alive, there's no way they're going to be able to sit in a hospital and make the decision to say, stop care. And they are able to now recognize that and be able to vocalize that and say, I'm going to take that out of their hands. I'm going to take that, relieve that burden from them. And I am going to name my adult daughter or my adult son to do this. I would say, particularly if we're getting into naming children, a lot of times they are naming the same ones as handling the financial affair. But
Sure.
again, it just varies. Sometimes people do want the people that have sort of the emotional tie. And then some
Right.
people like the financial people that say they're, I don't want to say emotionless, but that,
Yes.
that they, a little bit more matter of fact. And so it depends upon who it is they're going to name.
Yeah, this is such a good kind of nuance to this topic because I've had many clients where we spend quite a bit of time, letting them. I'm letting them know it's okay if you don't pick the same child. And just as
Yes.
you're saying, there can be reasons for it, but it does somehow feel like a fairness issue, or they're worried what the child will
I know.
think, and you just got to get past that and just be like,
Well,
what's
and
what's good
we
for you?
also always joke when we get those comments to say some of these jobs are a thankless job. And if
Yeah,
the child is smart, they actually might be happy that they haven't been nominated in some
that's
of
right.
these roles. But
When would you maybe not want to name a child though for this healthcare directive role?
I think again, it would be if the child, if the children or the child, one, certainly younger adults still where, there might be still needing to, they might technically be adults, but their maturity level, responsibility, they might not want to put, that emotion or that really strong emotional decision on their shoulders. And then certainly if you do not believe that they will follow through with what your wishes are. I think
Sure,
is
sure.
usually the case. So, and again, I think it's also, you mentioned about the spouses. I think it's also really important for people to understand the default are not to parents. So again, you have a young 20-year-old child that does not default to you as a parent. And certainly as we're starting to see, unfortunately, very splendid families, parents are divorced and, they don't get along. It is very important for that child to also have that in place so that they are able to select who they might want in some of those situations.
Yeah, absolutely. That I can just imagine just coming off your 18th birthday, or maybe you're still just in college, right? And no one's
Yes,
thinking about estate planning
I know.
stuff right then.
I
But
know.
this is super
Yeah.
important to get in place.
Well, and
Well,
the common mainstream example that I give people for them to understand, Britney Spears. I mean, that is in essence what
sure.
her legal battle had gone through was a guardianship and a conservatorship because she was an adult and people deemed that she was not able to handle these matters anymore.
Right, right. Well, okay, so that's the healthcare directive side,
Yes.
health decisions.
Yes.
What talked about, I think it's a power of attorney, maybe the next
Yes.
piece.
Yes. And I think, again, a common sort of misconception people will have, they'll say, I'm the power of attorney. And just to clear up, the document is the power of attorney, and then it is a named agent. We refer to that typically as an attorney in fact. And so I think that's also important because people will think, oh, am I being named as the attorney? And I said, no, I don't get named in your documents, but it's an attorney in fact. It is somebody that is really stepping into your shoes that can execute documents, that can handle your financial affairs as if it were you doing that and taking those actions. This one is I would say, I mean, yes, your medical care is obviously very important, but this one is also what we would sort of refer to as a dangerous document because you are giving people access to your financial world, and so you really have to trust them that they'll do right by you, that they'll act in good faith, they'll act in your best interests.
Right. Well, and so I think of this similar to the healthcare directive. Are there not some defaults that happen if you're married? Is it not
No,
just
correct. They don't. And I think, and you probably run into this, I think a lot of spouses will think, oh, well, we own everything jointly. And I always say
Mhm.
you probably view it that way, but you certainly have things that are just in your names. Your IRAs, your 401ks, your life insurance policies. And I always say, just because you might be the beneficiary of your spouse's account or their policies while they are living, you do not have access. You do not have authority to truthfully call Matt and talk about those accounts if you're not on them. I always also talk with clients when they're of that age where they're having to start taking required minimum distributions. If that person is incapacitated, I say that the government doesn't care that you're incapacitated. They're going to want you to take that RMD, and we need to have somebody in place to be able to do that, to be able to execute that decision and withdraw that required minimum distribution so that you get to avoid those penalties and fees.
right?
I would say another big one that people often overlook, it's real property. So again, I think a lot of times, and this is, I don't know if this is entirely specific to Minnesota, but when you own property jointly, particularly if you are married, you cannot unilaterally sell the property. And the one quirk here in Minnesota is even if your spouse is not on the title to the property, you need your spouse's consent and signature when you transfer or sell that property. And so if you were in the midst of selling your home and one of the spouses became incapacitated, the other one wouldn't be able to proceed with that sale. But having that power of attorney allows them to do that.
Okay, that makes a lot of sense. So far we're talking about just the basics, right? So we've got the healthcare covered, someone
Yes.
to handle financial decisions.
Yes.
What are the other couple of pieces that are the basics?
Yes. I mean, I think one that often gets overlooked, actually, which is a little bit more in your realm, are beneficiary designations. So when people are talking about their estate and sort of what goes well or what gets messed up when somebody passes away, it's really making sure that those beneficiary designations are reviewed and that they're updated. With that is really important, and it's something that, you know, we certainly can address at a later time and go into more depth, is if you have a 5 and a 3-year-old, we probably don't want to name them under your life insurance policy as direct beneficiaries. So
Sure.
again, it's making sure we're reviewing them and that we're naming the correct people. You also don't want to name your sister who you think is going to take the kids in the event you and your spouse have passed away, because now that's your sister's money. You know, you pass away, that life insurance policy pays to them. They technically
Right.
have no obligation to use it. So beneficiary designations are really, really important to make sure that they're up to date and they're clean.
Yeah, and just to poke into that a little bit more, what would happen if the minor children were named as
Yep.
beneficiaries on a large life
Yes.
insurance policy?
And yes, and actually we didn't address it, which is also with regards to that power of attorney. It's the same process, which is it's called a conservatorship. So it is having to go to court and get somebody appointed to oversee the assets for, again, if you're incapacitated, so you're a vulnerable adult or you're an incapacitated person, that conservatorship would obviously oversee their financial affairs, but it's the same thing with regards to minor children. So if minor children inherit money outright, it is a proceeding in the court system. Here we have two sort of proceedings. One's called a protective order. And what that means is that the money goes into an account and it does not get touched. You cannot access it. It just sits there until they turn the age of majority, which I believe has actually sort of uniformly gotten updated to 21. It used to be 18.
Was a mix in the States.
Correct. And if somebody needs more access to the funds, then it would be under that conservatorship. And the conservatorship is tough. Usually the conservator has to be what's called bonded, so they are insured. There is a court hearing that has to happen to get appointed. And the conservator is required to do what we call an annual accounting. So they have to report to the court every year about what funds have been spent. Certainly if the funds have sort of increased, created any interest, and they have to get that approved by the court annually.
So in other words, you think you're doing the right thing by taking care of your kids, right? If something happens, and you are, but you're also creating a number of problems just to
Yes,
use that money to fund their school and fund their everyday life. And they're staying at Aunt
100%.
Susie's house, but Aunt Susie's struggling to like have the money to use for their
Yes.
well-being.
Yes. And usually, again, the order would say, there's like sort of a certain amount and obviously sort of maybe the normal everyday expenses. But if you ever had to wanted to give above and beyond, maybe that child's a teenager and is looking to purchase a car so that they can get to and from work, that's usually then a petition back to the court to get approval for that expenditure.
Interesting. So beneficiary is another super important, just kind of basic, just
Yes,
the blocking and tackling side. All right. And then of
exactly.
course the big one would be everybody talks about a will. They think that
Yes.
is the estate plan, but maybe
Yes.
touch on
Yes.
that.
No, so again, when we talk about the plan, we really want to say what happens while you're living, but you're incapacitated. And we talked about those two documents. It is important to know that once you pass away, then those two documents are no longer effective. And so now it is having a plan in place to say, what is going to happen with your estate and who is going to oversee that? there's sort of these two routes that people go through, their state goes through, which is what we refer to as probate and then non-probate. I know that that term probate can be a scary word for a lot of
Yeah.
people. And again, it depends
Avoid it at
upon the
all
state.
costs is what
I
I hear.
know. And you do in certain states. One, I don't want to pick on anybody in California, but California is a tough state to go through the probate process. And part of that is because they charge fees based on the value of the estate. So the attorney's fees, the court filing fees, the what we call the executor fees, or in Minnesota we refer to as a personal representative fees, that is statutory based, and that can eat away at a lot of funds. So there are states that you want to avoid it at all costs. There are some states like Minnesota where it's really not that bad. But it's important to know, I think a lot of times people will come to us and say, well, I need a will because I want to avoid probate.
Right.
And your will governs your probate assets. So when people pass without a will, we say it's dying intestate, and the state statutes will dictate what happens to your estate. A will then at least is just saying, I get to choose how I want my estate to go. I get to choose who's going to oversee my estate. I get to choose how my funds are distributed. The will is another big important document for people, particularly again with minor children, because it's dealing with guardianships. So in Minnesota, guardians have to be appointed under their will.
Okay, that's another huge one.
Yes.
It sounds like it all fits together. We're running from you're not well, you got the healthcare directive to help determine, or at least make sure your wishes are known with that. The power of attorney to pick up when you can't make decisions and you got to have someone carry on your financial affairs. And then the beneficiaries for when you do pass on to get the assets to the right spot. And then the will, that sounds super key to take care of everything else. Plus the guardianship, that's huge.
Yes.
The executor, talk about the executor. Where does that come in to the will? And I think sometimes clients confuse, well, I have power of attorney, I get to take care of all the financial assets.
Right.
So
correct. So just because you're named under the power of attorney, their default isn't then you are automatically the executor at their passing. And again, in Minnesota, we refer to this role as the personal representative, but again, commonly it's referred to as the executor. And again, if you don't have a will, the state statutes will dictate who gets to be nominated in that role. This person is tasked with collecting your assets. They're tasked with possibly selling any real property at that point. They are tasked with sort of determining what debts are out there, what bills should be paid. Most states usually probably have what we call a classification of claims. So there's an order of priority that things get paid with regards to sort of administering the estate, funeral costs, possibly taxes, things of that nature. The personal representative is usually tasked with doing that last year of life income tax return. So they're, tasked with having to make sure that that gets filed. And then certainly if we have what we refer to as a taxable estate, so that they have to do what we refer to as an estate tax return, they are charged with that.
Sure.
And then they're tasked to follow the wishes of the will. What happens now once sort of all the administration stuff is settled? Then what happens to those funds? Do they get distributed to the different beneficiaries? And again, under a will, we refer to them as a devotee. Or do we want to direct it to a trust for minor children, for example?
Okay. Yeah, very good. Well, as we're kind of like tying this all together, I know we've talked about a couple little examples here as we've gone, but can you think of maybe a client you've worked with that they could just provide some stark example of what happens when you don't have some of these things in place?
Yes, I mean, I would say a big piece. Actually, we had a situation recently where I know that the mother, and this was not a plan that we had sort of worked on, but years ago, a mother who was aging had put a plan in place and tried to get some assets out of her estate from what we refer to as sort of a medical assistance planning, sort of that elder care and possibly recognizing they were going to need long-term care. And again, that's something, a whole other conversation that you probably could have. Well, in that process, they had gotten assets to a daughter, and particularly a home, well, that daughter happened to be a single individual. They did not have any children. And, people just automatically think sort of the natural way of life will happen. Parents will pass first, and then children, and then grandchildren, and so forth. Well, this daughter actually predeceased mom, and she did not have a plan in place. And that house went back to mom. So they had done all this pre-planning, all this work and effort to get this asset out of mom's estate. And what I think, people don't think about or ask the questions is, what would happen if I didn't have this in place? And so, as I mentioned, we refer to that as called dying intestate. And the state statutes will say, here's where your assets will go when you pass away if you don't have a will. And again, I think that's another common misconception. People come in and they'll say, I need a will because I don't want the state to get all my assets. And I say, well, the state doesn't really want your assets, but they will dictate where they go. And so most people, we refer to this as heirs at law. It's their spouse. If not spouse, it's children, and you sort of go down the line, then grandchildren and so forth. But it's important for people to recognize, you go back up that tree. It's parents, if not parents, siblings, nieces and nephews, and so forth. And then you go back up the tree, grandparents.
Interesting.
And again, I think particularly, you would think that to a certain extent, a single individual could sometimes be the easier person to plan for. And truthfully, sometimes it is a little bit more difficult, or it's, I would say, possibly more important to plan for, because it is important to understand, well, what would happen if they don't have a plan in place? Where do these assets go? I've had some, friends who at the time weren't married, and, I know personally that they're estranged from one of their parents, and they'll say, well, I just would want it to go to my mom. Isn't that what would happen? And I say, well, it actually will go to your dad as well, because just because you don't talk to your dad, I mean, they're still your dad, and they get 50-50. And so I think it's understanding that light bulb moment to say, oh, I wouldn't have assumed that that's the way it would go.
Right. In other words, if you have an estate plan in place, whether you've made the choices or not.
Very true. Very true. Sometimes when I do seminars, I ask the audience who has an estate plan, and very few people raise their hand, and I say, actually, all of you do. It's just whether or not you've actually been able to draft it, or you've actually had the choice. And I think the other big piece is the guardianship piece. I always joke with clients. I say, it's probably going to be the family member you don't want to take on your kids that will be the ones that rush to the court, and raise their hand first. And so it's really important that you get to be proactive with regards to that. So
absolutely. There's so much more we could talk about. In fact, I think in the next episode, we'll move on to some kind of advanced topics, which, what comes next, and trusts and taxes, and everybody has questions about some of the more fancy terms maybe they've heard. But, this has been really good. I mean, the thing is, if you want to have a plan for those unexpected events, I mean, you really need to start early. You need to just get the basics in place, and you need to kind of review this on a somewhat regular basis, because things change.
Well, and it's one thing too important, like you said, it's not set in stone. Mm-hmm. So sometimes, again, I also think of it like an artist, right? They always say, the blank canvas is the sort of the scariest piece. Get a plan in place for today. If in 3 or 5 years from now, you look at it and you'd say, what was I thinking naming my sister being, the guardian? Those can get updated. And I used to think it was, you're planning for so far down the future, but we're not. We really are saying, if God forbid something happens tomorrow, what would you want to have happen?
Yep, that's great. Very good advice. Well, Bill, before we keep going on, because I know there's lots of questions I have for Jen. Why don't you close us out, and we'll come back another day.
Well, why don't you sit on those questions, because we can take those up in part 2.
All right.
This is a great conversation. I'm going to walk away with this one simple fact. You have an estate plan, whether you know it or not.
Mm-hmm. It's true.
So you got a choice. You can either let the state decide, or, maybe you want to be the one that decides. So we'll take that away for now. Part 2, I can't wait to get into, and I'm looking forward to that. I'm sure listeners are as well. We can deal with that right now. If you are listening to this podcast and you are not a subscriber, hit subscribe. That way, when the next episode comes out, you will be notified about it. You don't have to think about, gee, I got to remember, where did I hear that? You'll be notified. You'll be told. It'll be delivered to you. And you can listen to part 2 of the podcast. Matt, until we come back, if anybody wants to get in touch with you, what's the best way for them to do that?
And I'll start actually with, you might want to actually get in touch with Jen, and I think you could jump out to her website. Jen, what's the best place for people to look up you?
Yep, that would be great. The website is Sykora Santini, SYKORASANTINI.com.
Excellent. Love the names. It sounds so exotic. It was a great like combo, the two of those. We'll put that in the show notes though, so people can find it and don't have to write it down when they're driving. But you can also check our website then, perspective6group.com, the number 6. And there's information out there how to get a hold of us. You can also call us 952-225-0333.
Good. Excellent. And if you want any like a little trick, just remember the great Santini.
Yeah, exactly.
She's right here.
There you go.
Jen is here. You've met her, ladies and gentlemen. Until next time, I'm Bill Tucker on behalf of Matt and everybody at Perspective 6. Thank you for taking the time to listen today. And we want to remind you that you can go out today and make it a great day or not. It's your choice. Have a great day.